Let's talk about reasons why employees and job applicants should seek help from the EEOC. Now, before I get into it, because I always forget this, I want to make sure that you all know I have a book, a journal available on Amazon.com. So, for any of you who've been trying to figure out how to document everything, I have a journal available on Amazon.com that takes all the guesswork out. So, you can use any journal, but I just want you to start documenting the things that happen to you at work. So whether you choose my journal, is called Document Everything, available on Amazon, or whether you choose some other journal, please start making sure you document all these things that happen to you at work, because it makes a difference. Anytime an employee comes to me and they have documented everything, it makes such a big difference when it comes to settlement discussions. So anyway, I want to talk today about reasons why employees and job applicants should seek help from the EEOC. 7 reasons in particular. Now, let me say this. I understand that people have different feelings about the EEOC. I hear you on that, and we'll talk a little bit about that. But the purpose of today's discussion is to make sure that you don't miss out on very important deadlines. Make sure you check the EEOC website to comply with deadlines even during the shutdown, because just because we're in a shutdown and just because the EEOC is not fully operational does not mean that you are relieved of your obligation to file your charges of discrimination if you need to. So you can file a charge of discrimination online, and the government shutdown is probably not going to excuse you from doing so in a timely manner. But if you go to their website, you can see for yourself what their specific guidelines are. Just understand that regardless of how you feel about the EEOC, we kind of have to go through them. So with that said, let's get into 7 reasons why employees and job applicants should seek help from the EEOC. The first reason is that you believe you have been treated unfairly in the workplace due to a protected characteristic or as an act of retaliation. Now let's break that down. What does it mean to be treated unfairly because of a protected characteristic? So a lot of times in law, you see these statements like this, and it sounds pretty straightforward, but it's never straightforward. That is why we end up spending so much time in law school understanding how to decipher these statutes, because they never really just mean what people think they mean. On its face, it sounds like it's pretty straightforward. One person might think unfairly means one thing and somebody else thinks another thing. So the word unfairly is misleading. And then you have protected characteristic. What in the world is a protected characteristic? And people come up with all different reasons or different explanations as to what a protected characteristic is. So let's break that down. Being treated unfairly in the workplace. So that is the first part of it. So people are treated unfairly in the workplace all the time. There's a difference between being treated unfairly and being treated illegally. And so when that being treated unfairly rises to the level of being treated illegally, is when that second part comes in. So being treated unfairly at work due to a protected characteristic. So what they're saying is, yes, you've been treated unfairly, but not just being treated unfairly in general. It's specifically because of a protected characteristic. A protected characteristic is your age, race, sex, gender, disability, those things. There are only a handful of categories. And protected characteristics are not specific to one race. Specific to one gender. It always depends on the circumstances. So you can bring a gender discrimination claim and be a man. That makes sense, right? If you are a man and all the women are getting the preferential treatment, then it's gender discrimination based on gender, even though you're a man. People tend to think that if you're bringing a gender discrimination claim, it must be a woman, but that's not the case. If you are the only black person and everybody else is outside of your race, then you would be protected because you are unique in that situation. Or you, by the same token, can be a white person working with all people of color. You, as the white person, are protected because everybody else is different from you. So people don't understand that it doesn't matter what your race is, what your gender is. It matters what your race or gender, etc., is in the particular set of circumstances. So if you believe you've been treated unfairly in the workplace due to a protected characteristic, whatever that characteristic is, or as an act of retaliation. So either treated unfairly, meaning that they're giving all the overtime to the people under 40. The people over 40 aren't getting it because they're saying you don't need it. That's age discrimination. They're treating you less favorably because of your age. So but what's interesting is with age discrimination cases, I've had so many people come to me, younger people, and wonder if they could sue for age discrimination because they were making them do all the work and the people over 40 were getting treated more favorably. It doesn't go that way though. It only, age discrimination claims only come in for people 40 and older. So there's that. But in any event, so that's what we mean about being treated less favorably because of a protected characteristic, not just generally being treated unfavorably, not just your boss is micromanaging you because he doesn't like you, because he doesn't like the music you listen to. That's not music taste, music preferences. It's not a protected characteristic. Think about it like this. The law protects people who have a characteristic that they can't change. Well, these days, I guess you can change anything, but typically that was the thinking. Something that you have no control over. You're a woman. You're born a woman. That's what you are. Again, things are different these days, but when these laws were written, this is what the thinking was. If you are a certain age, you're a certain age, and you can't change that. And so the law tries to protect people for things that just are and that you have no control over. Again, but it's not related to only one race or age or etc. And the second part of that is if you've been treated unfairly at work because of your protected characteristic or as an act of retaliation. Number two, if you have been denied a promotion or if the company has refused to hire you or they've laid you off as a result of your age, race, sex, protected characteristic, then you should complain to the EEOC. And so sometimes people don't necessarily realize that you can bring a claim against a company even though you don't work there. If you try to get a job and they didn't hire you and you have evidence that they didn't hire you because of a protected characteristic, then you have what we call standing, the right. You have the right to sue that company because they refuse to hire you because of your age or gender, or if they refuse to promote you for that reason. For example, I had a case where my client already worked for a company and he wanted to apply for a receptionist position. And they refused to give him the job, and they were not very savvy about keeping it to themselves. Their justification for not hiring him didn't keep it to themselves. What they said was, well, we prefer someone with a softer voice, so we're going to go with a woman. Yeah, so I thank them for that. So they quickly settled that case because, they outright admitted that they were not hiring him, or I should say not promoting him because of his gender. He's a man, they wanted a woman because they wanted someone with a softer voice. So that's an example of refusing to promote someone or hire someone because of their gender or because of a protected characteristic. I've had cases where the person I represented was so incredibly more qualified than the people who got the job. And this, I'm thinking about one case in particular. This woman had no experience working for this company. She wasn't already working there, and they refused to hire her. And she had so much more going for her in terms of education, experience, etc., and said they hired a white female. It was just very apparent that what was going on, and so they settled the case. So that's another example of where you can go to the EEOC. You should go to the EEOC and file a charge of discrimination and sue if you believe that you were denied a promotion because of a protected category characteristic. I had another case where my client had been with the company forever, like had spent his entire career there, from clerking during or interning during college to that being his only job. And he'd been there for 20 plus years. And they refused to promote him beyond a certain level. He would train people and then end up having to report to them. And it was a sad, sad story. And we fought tooth and nail. They did everything to get around promoting him. So they would have these interim positions come up. Maybe somebody's leaving and they wouldn't post the job. What they would do is just pick someone to put in the job, the person they wanted to have the job. And when it came time to post the job, the person that they put in the job on an interim basis obviously had more experience. And so they would do these panel interviews, and obviously the person who'd already been doing the job would give fantastic answers because they've been doing the job for a whole year, you think? So they would argue, well, we had this panel and the panel interviewed all these people and your person didn't answer as well as everybody else. And so anyway, I had to fight that case for like 5 years. The lower court dismissed it, said we didn't have enough evidence to prove our case. We appealed all the way to the 11th Circuit, and I got the judge reversed, and my client eventually ended up getting a really nice settlement. So that's an example of a company refusing to promote a person because of their race, person already working there. So I see lots of different things, but when any of this happens, whether you're already working for the company or you're looking to work for the company, it makes sense to file a charge of discrimination with the EEOC. A third reason you should file a charge of discrimination with the EEOC is when you are experiencing unfair and illegal treatment when it comes to your wages, your benefits, or just, we can call it compensation. Now, Equal Pay Act is where you've got people of a woman and a man doing the exact same job, doing the exact same work, but then you have the woman making less money. Now, you don't have to go through the EEOC for Equal Pay Act claims. I say go anyway because you can couch it as sex discrimination, gender discrimination. But in any event, if you are being paid less because of your gender, then that is absolutely a reason to go to the EEOC. So whether it's an Equal Pay Act claim or a sex gender discrimination claim, that is a reason to go to the EEOC. Number 4, you're working in a hostile work environment. Now, this is something people get confused about all the time. When we say hostile work environment, under the law, it has a very specific meaning. Hostile work environment doesn't mean that everybody's just making fun of you. It's going to always come back to your protected class status. If you are experiencing repeated jokes about your age, when are you going to retire? Man, you're the old man in the house. When you keep hearing things like that and management refuses to do anything about it, it's making it really hard for you to go to work because they won't stop talking about your age. They won't stop asking you when you're going to retire. They won't stop calling you the old head. They won't let your age go. That would be an example of a hostile work environment. You can't even work. You can't even get your stuff done because they keep talking about you, keep making your age, for example, an issue. So a hostile work environment is certainly what probably comes to mind for most people, where you're just being terrorized basically, but it's not being terrorized in general. You have to be, again, asserting claims because of your age, race, sex, gender, disability, religion. So again, hostile work environment is a term of art. It means you're working in this environment that is just horrible because people keep jabbing. People will not let go, talking about and making your work life miserable because of your protected characteristic. Number five, if your employer denies your request for a reasonable workplace accommodation because of a disability or pregnancy or religious beliefs, for example, then you should complain to the EEOC. Your employer has an obligation to provide reasonable workplace accommodations so long as, and this holds true for all of these, so long as your employer is governed by the EEOC. So if you work for a really small mom and pop where there are only like 2 or 3 employees, they're probably not going to be subject to Title VII, which is where all of these protections come from. Sometimes there are still state laws. EEOC is under federal law, but then sometimes there are still state laws that might protect you. Anytime I'm talking about private companies that are subject to Title VII. So, for example, you have to have at least 15 employees, have to cross interstate lines. So there are all of these requirements, but almost all employers are subjected to Title VII. So again, one example is if you're just a couple of employees, you might not be, but for the most part, employers are required to comply with Title VII of the Civil Rights Act. And the only reason that an employer would be okay not giving you an employer a reasonable accommodation is because it creates an undue burden on the workplace. So I had a case, for example, where a woman wanted to, where she worked at a pediatrician's office, and she said that she was getting more religious as she went along. So when she started working there, she just showed up to work in regular clothes, but then she started wearing a hijab, and then she said, "I want to cover my entire face." Well, you imagine this woman working with small kids and coming in completely masked and working in a medical lab where she, that just kind of wouldn't work out there. So anyway, she was not allowed to wear a complete, cover her face completely, working in this facility with small kids at this pediatrician's office. So that is one instance where the organization, the company could say, listen, I hear you and I would be happy to accommodate your religious beliefs, but that's going to hurt my business. I can't do that. So that would be an example of where accommodating a person's request for a reasonable accommodation would create an undue hardship on the job. Number 6, retaliation. And I discussed a little bit about this early on. But again, to remind you, if you have recently complained about illegal behavior, about your employer participating in behavior that is illegal, so whether it's failing to pay overtime when they know they're supposed to, or whether it's participating in age discrimination, or maybe you participate in an investigation where your company is being investigated for race discrimination, whatever it is, if you have had some involvement with reporting or testifying about your company's illegal behavior, and then your company comes back and tries to get at you, tries to take action by demoting you, firing you, or otherwise treating you less favorably because of your participation in an investigation, or because you complain about unfair treatment, then that's retaliation. And it is a separate claim from just straight discrimination claims or harassment claims. You should go to the EEOC and file a retaliation claim. And number 7, and this is the most important one, you should go to the EEOC because it is a required step. If you want to file a discrimination claim against your employer, there are certain exceptions. Like I said, Equal Pay Act is one. There are Like you can file a race discrimination claim under a different statute, but by and large, if you want to sue your employer, the EEOC has to be the first stop. Not because you think that they're going to do something great for you. Don't hold your breath. That has nothing to do with it. The fact is, they have what you need, and it's called a notice of right to sue. So when you get ready to file your lawsuit in court, you need to be able to present that notice of right to sue to show that you took the necessary steps before filing a case in court. And that's just not optional. If you are required to go to the EEOC first, and in most instances you're required to complain to the EEOC about your employer before you can actually sue your employer. If you're required to do it and you don't do it, then it's like game over before your case even begins. So make sure you go to the EEOC and make sure you go within the time frame that's required. You don't have a lot of time. So again, I encourage you to visit the EEOC website so that you can get more details on what you are required to do. So those are 7 very basic things, reasons to go to seek help from the EEOC. And again, I know that there have been a lot of people who have had a lot of bad experiences with the EEOC, but unfortunately, you still don't get to skip the EEOC, regardless of how you feel about them. So a lot of times you can avoid some of the problems that people complain about by hiring a lawyer first. Because when someone hires me before going to the EEOC, I don't have to go through near the stuff that they have to go through. I don't have to wait to have an appointment with the EEOC. It's just easier when you have a lawyer, and you can avoid a lot of the problems that people complain about. It's a very different experience when you have counsel. I understand everybody cannot afford counsel before going to the EEOC, and you certainly don't want to miss any deadlines because you're seeking to hire a lawyer. I certainly don't advise that, but I just mention that because I know that it makes a difference. So anyway, I'll see you next shift.